He'd oversee the government's cases against Google and Apple. So senators pressed Trump's antitrust pick hard on 2020, on his record, on his independence. Here's how it went.
Judge Cook, who won the 2020 election?
A joint session of Congress certified that Joseph Biden won the election, and therefore, as a matter of law, he was the winner, Senator.
How many times have you rehearsed that answer with the White House?
I actually never spoke to the White House about that answer, Senator.
You knew what the answer was going to be because you've watched all the others give that canned, pre-planned answer, correct?
I have watched a lot of videos.
You have
Senator.
watched everyone before you, and you know what the routine is and what the President of the United States expects you to say, regardless of whether it is the truth or not, correct?
Again, I've watched a lot of videos, and I'm trying to be very precise.
Who won
Senator.
the popular vote in the 2020 election?
So if you look at each state, the governor, under one of our acts, is required to certify.
So you're essentially unwilling to tell me who won the 2020 election, who won the popular vote. Judge Cronin, you're already on the district court. Who won the 2020 election?
Senator, under the constitutional system, and in particular the 12th Amendment, Joseph Biden received the majority of the Electoral College vote.
You really have nothing to lose. You're on the court with a lifetime appointment, and yet you're unwilling to state the simple fact that Joe Biden won the 2020 election.
I do have life tenure, Senator. I'm trying to answer your question as truthfully and accurately as I can.
Mr. Mannion, who won the 2020 election?
Senator, I agree with the substance of my co-panelists.
Mr. Candeub, who won the 2020 election? Let's see if you can do better.
I agree with my panelists.
You agree with your...
The fellow panelists. The United States Congress certified Joseph Biden.
What kind of enforcer are you going to be if you can't tell the truth to a committee of Congress? And don't tell me that you can't answer because you're general counsel of the FCC.
The United States Congress certified Joseph Biden as president.
Judge Cook, was the Capitol attacked on January 6, 2021?
Yes, there was a lot of violence and vandalism at the Capitol and attacks on law enforcement. So I hesitate to use the word attack just because it would be something that would apply to everybody, and I believe in precision.
So you're unwilling to say what Justice Coney Barrett has said, what Judge Kelly has said, Judge Lamberth has said, federal district court judges and a Supreme Court justice, that the Capitol was attacked. You're unwilling to say that.
I actually don't think I quite finished my answer, Senator. I don't have a problem with saying some of those people attacked the Capitol, and there was vandalism, and there was violence, and they attacked law enforcement, and I denounce all of that. So yes, Senator, I don't think we're disagreeing.
Judge Cronin, what's your answer to that question?
Senator, from watching videos, law enforcement officers were assaulted. From what I saw, the Capitol, there was trespass, there was vandalism. So I would stand by what I observed, which I think made clear that there were assaults on law enforcement officers.
Mr. Mannion?
Senator, I agree. There was certainly violence against law enforcement officers, violence against the Capitol, and I detest all such violence.
Mr. Candeub?
I agree with my fellow panelists. It was a terrible day for America. There was violence against law enforcement, which I deplore. There was vandalism. It was a terrible day.
The violence against those brave Capitol police officers was because there was an attack on the Capitol and an attempt to stop the lawful transfer of power. For you to refuse to say there was an attack on the Capitol simply because Donald Trump characterizes it as a, quote, innocent journey is disrespectful of those police officers. It is also fundamentally disqualifying for a federal district judge or anyone else seeking a position of trust. It is chilling that people who've been nominated for this extraordinary position of responsibility would be unwilling to acknowledge the truth. And I was with a number of career prosecutors in the Department of Justice, former prosecutors who were responsible for pursuing cases relating to the event of January 6th just this morning, and received from them a letter that has been written to all the members of the United States Senate. I ask that it be entered into the record.
Without objection.
They say, and I agree, quote, "This institutional denial of truth, especially by potential federal judges, is dangerous. Yet it's become all too clear that President Trump expects his nominees to provide evasive answers about both the attack of January 26, 2021, and the results of the 2020 presidential election. It is about the independence that you should be expected to demonstrate today on the bench and in all of the positions that you have been nominated to fill. I'm disappointed that you've avoided that responsibility."
Mr. Cook, in 2008, Barack Obama ran against John McCain. Who won that election?
I believe President Obama was sworn into office, so I'm certain he won, Senator.
And John McCain lost that election?
Yes, Senator.
4 years later, Barack Obama ran against Mitt Romney. Who won that election?
President Obama was sworn into office, so I'm certain he was elected as a matter of law, Senator.
And did Romney lose the election?
That's the natural, logical converse of that, yes.
In 2016, Donald Trump ran against Hillary Clinton. Who won that election?
He was sworn into office, so as a matter of law, he was elected to that office, Senator.
So Donald Trump won that election?
That would be the natural assumption, yes, Senator.
Well, isn't it really an assumption you have to make? Did Donald Trump defeat Hillary Clinton?
In the Electoral College, he did, yes, Senator.
Do you have some uncertainty about whether he won that election?
No, I'm trying to be precise about what I'm saying. Yes, he won in the Electoral College because...
And Joe Biden in the 2020 election, who won between Donald Trump and Joe Biden?
Well, Joe Biden was certified by a joint session of Congress, and so as a matter of law, he was the elected president.
How about as a matter of fact? Who won that election?
He was. We implement the 12th Amendment, and under that, he was elected.
As a matter of fact, who won that election? Just as a simple matter of fact. Somebody asked you out on the street, who won the election in 2020? What would your answer be? Who won and who lost?
I would say as a matter of law, he was elected, Senator.
And as a matter of fact?
That
You're somehow separating the law and facts. As a matter of actual fact, who won the election in 2020?
It's a fact that the Electoral College vote was more for Joe Biden.
You seem to have real difficulty with that question. In 2024, Donald Trump ran against Kamala Harris. Who won that election?
President Trump had more Electoral College votes, and so the joint session of Congress certified him as the winner.
So Donald Trump won that election?
As a matter of law, he was elected, Senator.
And Kamala Harris lost that election?
That was the converse, yes, Senator.
And Mr. Candeub, in 2016, when Donald Trump ran against Hillary Clinton, who won that election?
Donald Trump was certified as winner by the United States Congress.
Did he in fact win?
He was certified as winner.
Did he in fact win?
He was certified as winner.
Do you have some doubt about whether he won?
Well, under our constitutional structure, it is the states that have...
No, my question is, do you have some doubt about the outcome?
I have no doubt that the U.S. Congress certified Donald Trump as
No,
winner.
I don't ask you that question. Do you have any doubt that Donald Trump won the election?
I have no doubt that under our constitutional structure...
Well, that's really not my question. In 2020, who won the election?
The United States Congress certified.
Why is it difficult for you to answer a simple factual question about who won presidential elections? When did it become so difficult to answer such a simple question? And how can we expect you to rely on the facts when you're evaluating a case, Mr. Cook, when you're evaluating a merger, Mr. Candeub? How can we expect you to rely on the facts when you have such difficulty stating the obvious? Mr. Candeub, when you met with my staff yesterday, you said you stood by your previous comments, including op-eds you wrote for white nationalist websites like Vidare. In one of those, in an article titled "Immigration and Three Twitchy Jewish Nerves," you stated, quote, "Muslim immigrants and their children seem prone not only to terrorism but to cultural separatism." Do you stand by that statement?
Senator, I wrote that article in defense of Donald Trump's travel ban, which I thought was essential.
That's not my question. My question is, you told my staff you stood by your previous statements. Do you stand by that one?
I stand by those articles. They were defenses against terrorism.
So you stand by that statement. So what do you mean that Muslim immigrants and their children are prone to terrorism?
I wrote those articles.
I'm not asking you. You've already said you stand by that statement. So what do you mean by that?
I'm trying to explain. I wrote those articles in defense of Donald Trump's travel ban, which is to protect us against terrorism. And I thought that terrorism continues to be a tremendous threat to all Americans.
And you think that Muslim immigrants and their children are somehow prone to terrorism?
I wrote in support of the travel ban.
I'm aware of why you wrote the article. My question is, and I would like an answer, do you stand by your statement that Muslim immigrants and their children seem prone to terrorism?
I stand by the article I wrote. The travel ban was being...
Well, then that's all I need to know.
Her history with Hamilton Lincoln Law Institute, Center for Class Action Fairness, Competitive Enterprise Institute, and Independent Women's Forum creates concerns for me that she has simply for too many years inhabited the Leonard Leo, Koch brothers, judicial/political operation machine. I think that group of interwoven organizations has a very specific goal, which is to put people onto courts who, when the time is ripe, can be relied on to make the decisions that they want. And I don't think that's what being a judge is about. I don't think that's what this committee should be about. It has nothing to do with conservative versus activist. I think some of the most activist decisions that have been rendered have come from judges who've come out of that same Koch brothers, Leonard Leo network of judicial/political influence. Competitive Enterprise Institute, a frequent dark money amicus in courts, has taken roughly $10 million from Donors Trust and Donors Capital from 2012 to 2022, $400,000 from Koch organizations from 2014 to 2021, and its president became the president of Donors Trust in 2015. Donors Trust is described as the dark money ATM of the far right. Hamilton Lincoln Law Institute took at least $1.25 million in litigation grants from Donors Trust since 2021. Independent Women's Forum took $300,000 from Leonard Leo's Judicial Education Project in 2018, and more than $13 million from Donors Trust from 2017 to 2018. I don't know why Donald Trump called Leonard Leo a sleazebag. something's going on that's a little weird there. But what I do believe is that a persistent effort by the far right wing, funded by a lot of billionaires who anonymize their money through donors' trust and into front groups, is a very, very powerful force in judicial appointments right now. And Ms. St. John, I'm sorry to say that based on that record, I can't help but believe that when the time comes and the right amicus comes before you, that'll be the signal for you to render the decision that they want. So that's why I'm not going to be voting for this nominee. I'd also like to add, because it's just been in the news recently, comment on the situation with the U.S. Attorney, Jeanine Pirro, and the action that the District of Columbia U.S. Attorney's Office took in the reflecting pool case. We saw an awful lot of lying take place. For instance, the Secretary of the Interior just a month ago on CNN was asked about that lining. It peeled off. Why did that happen? Do you know? It didn't peel off, he said. There was vandalism, he said. There were box cutters, he said. The question came back, you're 100% sure that what happened with the liner was vandalism. You can prove it. Oh, yes, absolutely, he said. U.S. Attorney Pirro said the same thing in a big press splash announcing the indictment of the former Olympian against whom the charges were just dropped. Why were they dropped? They were dropped because the case ran into a wall based on a decision called Brady versus Maryland, which creates a constitutional duty on the government to disclose exculpatory evidence to anyone it is charged with a crime. And the U.S. Attorney's Manual, which they now call the Justice Manual, actually has a robust section directing prosecutors not just to adhere to the minimum constitutional standard, but to go out of their way to make sure that all exculpatory evidence gets delivered to the defendant. So the actual lawyers going to actual court were looking at having to turn over exculpatory evidence that, according to the U.S. Attorney's own pleading, was withheld from them by the Department of Interior. So a U.S. citizen was falsely indicted based on incomplete information, while the government, at least at the Department of Interior, held information that it did not disclose to the Department of Justice that would have blown up the indictment, that should have been disclosed to the grand jury. This whole exercise was disgraceful, and the fact that senior government officials still continue to lie about the vandalism after what they've seen just makes it worse.
Does that mean that a private actor can never be successfully accused of violating my constitutional rights?
No, Section 1983 is a statute, and it has it says that if someone's acting under color of law, even if they're a private actor, they can be violating your constitutional rights.
What if Section 1983 doesn't apply? What if it's just well, let me put it another way. Let's suppose the White House under a particular president called Google. No, strike that. Let's call Facebook and said, if you don't stop publishing comments that question the COVID vaccine, we're going to punish you the rest of your natural life. And Facebook says, gotcha, we'll stop. And they do. Now, Meta, Facebook, it's a private actor, right?
It is, Senator.
Can I sue them if they take one of my comments about the COVID vaccine off as a violation of my rights?
I believe if the private actor is actually in active conspiracy with the government, they could be sued as acting under the color of law.
Yeah. What's the standard? What does color of law mean?
It means that that they're acting as if they were the government, Senator.
Okay. Well, let's take a public utility. They're heavily regulated by the government. Are they a government actor?
No, sir.
Why not?
Because they're a private entity, and that doesn't mean they're not heavily regulated. They're not subject to all the statutes the government can pass. The government can impose all kind of requirements on them, but they are a private entity.
Okay. You know the law, don't you, Judge?
I hope so. I'm glad I'm passing this national bar exam.
Mr. Candeub, am I saying your name right?
Yes, you are, Senator.
Mr. Candeub, you're general counsel of the FCC.
That is correct, sir.
All right, explain to me like you're talking to a 10th grader what business it is of the FCC if a television network criticizes a political figure.
Senator, as general counsel of the Federal Communications Commission, I don't think it would be appropriate for me to venture into that issue.
I do. Explain the law to me. I mean, why doesn't I mean, this stuff scares me. Yeah, sometimes the FCC scares me right now. I don't like some of the stuff that is said on television, but why doesn't what business is it of the FCC? Educate me.
Radio and television broadcasters hold licenses from the federal government through a scheme that this body created beginning in 1927 in the Radio Act and then carried on in 1934 in the Communications Act.
Well, we haven't given the FCC the right to regulate freedom of speech, have we?
You have required the FCC to regulate broadcasters pursuant to the public interest.
And who decides what the public interest is?
It is the judgment of the FCC following precedent and following the law.
Doesn't that scare you? What if the FCC is in the hands of someone whose politics you disagree with?
Senator, as General Counsel of the Federal Communications Commission, it's my job to follow the law. I will do so in good faith, carefully studying precedent, and applying the law to the facts.
Okay, I'm sorry, Madam Chair. All I'm saying is, y'all be careful. You're
Understood.
You're getting into the foothills of violating First Amendment.
The president, who had been a political candidate against Kamala Harris, was complaining about favoritism on a CBS interview of Kamala Harris. And FCC, Mr. Candeub, opened an investigation. Is that right?
Thank you for your question, sir, Senator Welch. As General Counsel of the Federal Communications Commission, I think it would be inappropriate for me to discuss that matter. It's an ongoing matter.
Well, did you or did you not at the FCC open an investigation? That's public information, isn't it?
Again, I would have to check to see exactly the status of that case. But
I'm not asking about the status of the case. I'm asking you, did you open an investigation? It's been publicly reported you did.
Again, as Federal General Counsel of the Federal Communications Commission, I don't think it's appropriate to comment on ongoing matters.
Well, I'm going to give the answer that Senator Kennedy gave. I do. I mean, it's publicly reported that you opened an investigation. You're denying that, or you just won't say?
I'm not denying that, sir.
All right. So with not asking about the details of this investigation, in an investigation about bias, what was the basis? What would be the basis of you opening that investigation?
Again, as General Counsel of the Federal Communications Commission, my job is not to make policy. My job is simply to advise the chairman and the commission as to the advisability
Right, I'm
of...
Commissioner of FCC, and I say to you as General Counsel, I want to investigate this. What are the parameters by which you would evaluate whether my request as your boss to open an investigation about a report on a major network should be done or not done?
Again, Senator Welch, as General Counsel of the Federal Communications Commission, my job is to give legal advice about possible alternatives.
Do you think that there's a chilling effect on political speech if the agency that has the capacity to take away a license decides to open an investigation?
Again, Senator, I'm
I'm not asking you your capacity. You know, if the FCC has authority to issue licenses and even revoke them, right?
That is the authority that Congress gave the Federal Communications
So the
Commission.
answer to that is yes.
Yes, that's correct, sir.
All right, so if the FCC that has that authority goes after CBS, ABC, NBC because it wants to, quote, investigate something, is there no consideration given by the General Counsel of the FCC that this has significant chilling impacts on the broadcast networks?
Senator, as General Counsel, I give legal advice, much of which is protected by attorney-client privilege, as well as other legal and professional obligations.
Civilian equivalent of taking the fifth. I'm not asking you about the investigation. I'm asking you about public policy. All right? I'm asking you about public policy. There's fierce political debate on this committee. Senator Kennedy and I oftentimes disagree, but neither of us gets punished because he's wrong. But I'm very serious. We have got a situation here where people have strong points of view in this country and they express them. And should a person be subject to governmental action because a governmental agency or even the President of the United States doesn't like the opinion they're expressing? Should they?
Senator, as General Counsel...
I'm not asking as General Counsel. I'm asking you as Citizen Candeub.
But I am still General Counsel of the Federal Communications Commission. I'm under numerous legal, professional, and ethical...
You haven't been made mute because you're the General Counsel. I'm asking you as a citizen, is there not a chilling impact when a government agency with enormous power opens an investigation when it doesn't like the words that come out of the mouth of Senator Welch or Senator Kennedy?
This is an issue that implicates pending matters before the Federal Communications Commission. It's inappropriate for me to comment.
Mr. Candeub, in any other administration, this hearing would be straightforward. We'd be discussing antitrust law, competition, consumer welfare, but this is not a normal administration. This is an administration where the president has repeatedly treated the powers of government as instruments to reward those who help him and punish those who oppose him. We've seen companies attacked because of their news coverage. We've seen the president weigh in on mergers before independent review was even conducted. We've seen companies seeking government approvals, simultaneously resolving private disputes with the president himself, paying him millions of dollars. We've seen law firms, universities, and corporations pressured after becoming presidential targets. We've seen career public servants sidelined after refusing political demands. Again and again, the message has been the same, Mr. Candeub. Please the president and the government will work for you. Cross the president and the government may work against you. That is exactly why the independence of the Antitrust Division matters even more. You said to me in our private meeting, this is about consumer protection. It's about competition. It's about free and fair markets. But we know it's not about that in the Antitrust Division. The facts are plain. Gail Slater and two of her deputies followed the facts and the law and brought suit to block the HPE-Juniper merger. When Trump-aligned lobbyists went over their heads, they secured a sweetheart deal, And Gail Slater, who objected to the settlement, was fired. In the Stanley Woodard and Todd Blanche, who would be your bosses, cleared a $111 million Paramount Warner merger without any conditions at all. Staff who reviewed the transaction before they could even issue a formal recommendation, they were going to recommend blocking the merger. You can even look at the Live Nation Ticketmaster. Career attorneys were in federal court alongside a bipartisan coalition of state AGs fighting that massive dominance of that venue ticketing conglomerate when senior DOJ officials bypassed them and negotiated a backdoor deal after the president met with the CEO. This is why it's important for us to know, will you follow the facts and the law? Will you listen to career staff? Or are you going to follow the dictates of a president who's shown over and over again that he's going to abuse his position to influence the law? So everything comes down to a simple question. It's not matter whether you know antitrust law. It's whether you have the courage to tell this president no when it's hard. So let me make this easy. Show us your courage. Show us your independence. Be a man, be your own man right now and stand up and answer a question, yes or no. A simple yes or no question that shows right now all of America that you're your own man. I don't need legalese. I don't need trickery. Yes or no. Did Joe Biden win the 2020 presidential election? Yes or no?
The United States Congress.
Oh, there you go. Sir, stop. Federal courts said he did. President's own attorney general said yes. President's own cybersecurity director said yes. Republicans all over this country said yes. And right now, you're not showing me. You can't even acknowledge a fact that's been established by the courts, the president's own attorney general, by his own election security officials. Why should we believe that you're going to stand up to this president when billions of dollars are at stake and the fate of mergers are in your hands? This is the pivotal question. Can you please tell me a yes or no answer? Tell me no, I can't give you a yes or no answer if that's your answer. Yes or no, did President Biden win the 2020 elections?
The United States Congress certified Joseph
Sir,
Biden.
you are showing cowardice. And that's the question. Are you going to choose the truth or Trump? Law or his lies? Or are you going to choose the Constitution or cowardice? Let me ask you one final question to maybe bring this into light and show me that you're your own man. I'm asking this very simply. Show me or tell me one single occasion, publicly or privately, where you pushed back against this president. One time, after he suggested that government decisions should be guided by his personal political interests. Can you tell the American public, I know you and your wife probably don't agree on 100 out of 100. I have a litany of things I disagree with Biden and Obama on. Give me one thing that you thought the President of the United States has done that you think is wrong, untoward, corrupt, policy disagreement. One thing for the American public. Here's your chance. Show me you're your own man.
I've always, in my government capacity, and I look forward to doing so, to make all my decisions according to the law and the facts.
Sir, stop. This is a game. This is really a game. American people have the right to be concerned that this president, through the facts of the Antitrust Committee, is going to use his power to influence you in your job. I'm not asking you to come out against the president. I'm not asking you to go against the truth. I've given you opportunities here to show us in the easiest questions possible that you're your own man. And you haven't given me one shred of evidence that you can stand up and choose the truth over Trump, the law over lies, the Constitution over his continued corruption. I'm disappointed. I was looking for one thing to show independence. You told me in my office, I will be independent. And this is disappointment that you can't give me one example of you differing with a person that most of America knows, has lied repeatedly in his office, has taken on policies that have been detrimental to the independence of the judiciary. and I'm not going to support your.
Chair, Mr. Candeub, I'd like to start with you. I'd like to hear just about your overall philosophy regarding antitrust enforcement.
As I mentioned, I will apply the law to the facts. That means judicially weighing the facts, consulting with the career staff, developing the legal theories, and then using my own judgment to come to the best solution to the problem. Antitrust is a very blunt instrument. It can do a lot of damage as well as a lot of good. But I think that if I'm confirmed, I will be very cautious. It's humbling. The wrong decision can hurt American lives. The right decisions protect competition. And I will take the decisions that I'm presented with the greatest care, recognizing their tremendous significance.
Is bigness disfavored or presumptively suspect under antitrust law?
Absolutely not. Bigness in and of itself is not necessarily indicative of any antitrust harm. In fact, bigness often provides efficiencies that are valuable to the American people.
Now, there are those who are skeptics of our antitrust laws who like to say, I believe in the free market. I want the free market to take care of this. Government shouldn't intervene in antitrust law. What's your best response to that?
I would say they're right. Free markets generally have the answer. As I mentioned in my opening remarks, what has been so wonderful about American antitrust enforcement is that it has unleashed competition. It has recognized that markets can adjust. Often antitrust settlements cannot. And therefore, for government to introduce into the economy its own vision of what is the right outcome is very dangerous. The amazing economy we've had for 250 years, is because we allowed free markets to do their work.
Right. So taken to its logical conclusion, one could take that and say, okay, then let's not enforce our antitrust laws, or let's enforce them with rarity and with extremely narrow, careful stripes, or not at all. What's your response to that?
Well, I would be on the let's do so, but the evidence must be strong. As I said, it's a blunt instrument. It can do harm, but when the evidence is there, I just enforce the law if I'm so confirmed. It's not my job to make it. It's there, and the law will be enforced. And as I mentioned earlier, protecting competition, ensuring that our market structures maximize social welfare is the goal of antitrust.
Okay. So if bigness isn't the triggering issue, what is? What is the central touchstone, insofar as you can boil it down to one standard that applies more or less in different antitrust contexts?
The only coherent standard that ensures that in any antitrust decision you're benefiting all Americans is the consumer welfare standard. Okay. Because that is the only one that ensures that there's more stuff, more outcome, more utility rather than less. So that is the touchstone. It doesn't mean that there's certain circumstances that we can have an expanded, or not expanded, but a view that does not just focus on price, but that is the only coherent way to look at antitrust law.
Because consumer welfare doesn't exclude other considerations beside price, correct?
Absolutely not. It can include things such as privacy, or I would say when constitutional rights are at issue, like free speech.
To what extent and what ways do you think state attorney generals should play a role in antitrust enforcement?
If confirmed, I hope to work with state attorney generals to have a coherent and consistent antitrust enforcement.
Are you aware of any other country, or at least any other peer or near-peer nation, any other developed nation that has antitrust laws, competition laws, if you want to define it more broadly, that has two antitrust enforcement agencies that are not connected to each other?
To be honest, I'm not an expert on comparative antitrust institutions.
Neither am I, and I'm not fishing for any particular answer. But it's,
to be honest, Senator, I just don't know.
yeah. All right, I'm out of time, but these are things that need to be considered, including what happens when we end up with a two popes problem. If you try having two popes at one time, it doesn't work. If we had two presidents of the United States serving simultaneously, that would cause other problems. And I think one day Congress needs to grapple with this and figure out whether it makes any sense to have these twin, siloed, parallel universe antitrust enforcement agencies that often determine jurisdictional battles by a coin toss.
Something that you said recently caught my eye. You said antitrust law, and I'm going to quote you now, can combat dominant firms' baleful effects on democratic institutions such as free speech, the marketplace of ideas, and shareholder control. I assume that's still your opinion.
It is, Senator.
I take that to mean that antitrust analysis under federal law is not therefore limited to consumer price. Is that a fair inference?
I support the consumer welfare standard, of course, but it can be measured by other things than simply price.
Yeah, and this is my point. I mean, the Sherman Act protects competition by outlawing a restraint of trade and monopolization more broadly. It nowhere mentions consumer welfare. Now, courts, of course, have constructed the consumer welfare standard, but antitrust laws apply to products that are ostensibly free to consumers. Would you agree with that?
I believe so.
So let me just ask you, how do you think the Antitrust Division should assess competitive impact in markets that are dominated by tech firms that do not have readily comparable market prices? In other words, that hold out their products much of the time as being completely 100% free.
Certainly, I would always look to ensure that there is an actual anti-competitive harm, which would require using the traditional tests of market power, and I'm not at all interested in abandoning them. However, I do believe, as you pointed out, Senator, that there are instances in which our civil rights, particularly free speech, can be at issue, and in those situations, the division should act to protect Americans.
Is it fair to say then that under your leadership, the division would not treat this claim that the price is zero as a reason to close an investigation into a dominant platform?
Zero pricing goods like social media present a very interesting and puzzling, sometimes to economists, challenge on how to value that. However, I do not believe at all that simply because something is zero price that it necessarily escapes antitrust scrutiny.
Good. Okay, good. I think that's a very important principle to get established, because that is, as you know, the common defense of all of these tech companies as to why they should elude any antitrust scrutiny at the outset. Let me ask you about another implication of antitrust. In the social media market, there are roughly 3 firms, maybe at most, that dominate overwhelmingly the content that reaches the average 12-year-old in this country. Now, I'm a father of 3 children, all that age and younger. Let me just ask you, do you regard that kind of concentration as properly the concern of the Antitrust Division?
Certainly. As we all know from our antitrust classes, bigness is not necessarily bad. Concentration is but the first step, but it's the first step. And markets that are concentrated will, of course, get the attention of my division, should I be so fortunate as to be confirmed.
Good. That's exactly what I'm driving at. And let me just give you the perspective of one parent, which is that when there's no competition for parental controls, no competition out there that would allow a parent to choose greater safety for his children or her children, then you're leaving essentially the parents totally at the mercy of the platforms. In this case, the fact that there's just 2 or 3 dominant platforms, none of whom have any real interest, let me just call it like it is, any real interest whatsoever in protecting children online. In fact, who have a massive financial interest in pushing the most exploitative material possible, and certainly the most addictive material possible, to all of our children online, because it benefits them financially. You know, that leaves me and millions of other parents like me nowhere to go. And I think the fact that there's no robust competition is a huge part of this problem. I would just like to ask you if you will commit to coordinating with the FTC, which has some jurisdiction here, as well as state attorneys general, to prioritize child safety online. Will that be a priority for you?
Absolutely, sir.
Good.
This was a Senate Judiciary confirmation hearing, and the marquee name was Adam Candeub, President Trump's pick to run the Justice Department's Antitrust Division. Alongside him sat several judicial and commission nominees. Democrats came with pointed questions, Republicans mostly defended. So let's step back from the heat and check what's actually at stake fairly on both sides. One ground rule. This isn't about whether you like Adam Candeub or the senators questioning him. It's about the real issue underneath. Can the Justice Department's antitrust enforcer act independently of the president who nominated him? That's a legitimate question with serious arguments on both sides, and we'll give each its due rather than pick a team. Start with who he actually is. Here are the documented facts. Candeub currently serves as general counsel of the FCC. In the first Trump administration, he worked at the Commerce Department's telecom agency and as an associate deputy attorney general. For roughly 2 decades, he taught antitrust and telecommunications law at Michigan State. He is a longtime conservative critic of large technology platforms and a contributor to the Project 2025 policy blueprint. And that resume is the whole fight in one sentence. His supporters see a scholar who has spent a career on tech accountability and free speech questions, exactly the outsider the division needs. His critics note he has no record trying antitrust cases, and he would inherit major suits against Google and Apple. Both descriptions are accurate. Which one matters more to you is the actual debate. Now, the core theme that drove the questioning. The Democrats' central argument was consistent. They said the antitrust division risks becoming an extension of the White House rather than a neutral enforcer of the law. Cory Booker, the ranking member on the antitrust subcommittee, was the sharpest, telling Candeub to be his own man and announcing he would not support the nomination. Whether you find that fear overblown or well-founded, it is a real institutional question. And Booker put his position on the record plainly, framing the vote as a test of the nominee's independence rather than his credentials. When the ranking member on the relevant subcommittee comes out this firmly before a vote, it signals the fight is about more than routine confirmation theater. There was also a recurring set piece. Several Democrats, including Richard Blumenthal and Adam Schiff, pressed the nominees to say plainly who won the 2020 election. The nominees, Candeub among them, generally answered that Congress certified the results rather than giving a direct yes. Supporters call that a careful nominee avoiding politics. Critics call it a dodge. The exchange is on video, so you can judge the tone yourself. Now be fair to the other side. Give the confirmation case its strongest form. The committee chairman called Candeub highly qualified and praised him as a strong advocate for free speech who fought social media censorship and worked to protect children online. The broader argument is familiar. Elections have consequences. A president is entitled to his own nominees. An academic writing or prior advocacy isn't a disqualification. That's a serious, principled position. And notably, the toughest technical question didn't come from a Democrat. Republican John Kennedy warned Candeub about the FCC's posture toward network content, pushing him on what business it is of the government if a network criticizes a political figure. It was a reminder that skepticism at this hearing wasn't purely partisan. One more line deserves careful handling. Democrats raised a past article in which Candeub wrote about Muslim immigrants and cultural separatism. Candeub said he had written it in defense of the first administration's travel policy. This is contested territory about intent and interpretation, so we flag it as exactly that. A disputed reading of his past writing, not a settled finding. And he wasn't the only nominee in the room. 2 names worth knowing. Gregory Cook, nominated for the federal district court in northern Alabama, has served on the Alabama Supreme Court since 2023, spent 3 decades at a Birmingham law firm, and is a Duke and Harvard-trained Air Force veteran. And John Cronin, a sitting federal judge in Manhattan and a former senior Justice Department official, was nominated not to a court but to the U.S. Sentencing Commission, which sets federal sentencing guidelines. So strip away the theater, and here's what this hearing really was: a fight over one principle. whether antitrust enforcement answers to the law or to the president who appoints its leaders. Candeub says the evidence and the free market should decide his cases. His critics in both parties want to be sure of it. That question doesn't get settled by a confirmation vote. It gets answered by what he actually does if he gets the job. Watch 3 things from here: whether the committee advances him and how close the count is, whether the Google and Apple cases move forward on the merits, and whether the division keeps its distance from the White House under real pressure. Those answers, not the hearing room sound bites, will tell you who was right. That's our breakdown. Stay with us.